Introduction. Civil law classification of property. 1. Things are divided into common, public, and private, corporeals and incorporeals, and movables and immovables. B. Corporeal and incorporeal things. 1. Corporeals are things that have a body, whether animate or inanimate, and can be felt or touched. Incorporeals are things that have no body, but are comprehended by the understanding such as rights of inheritance, servitudes, obligations, and right of intellectual property. C. Movable and immovable things. 1. Movables. A. Corporeal movables. 1. Corporeal movables are things, whether animate or inanimate, that normally move or can be moved from one place to another. B. Incorporeal movables. Rights, obligations, and actions that apply to a movable thing are incorporeal movables. Movables are such as bonds, annuities, and interest or shares in entities possessing juridical personality. Interest or shares in a juridical person that owns immovables are considered as movables, as long as that entity exists. Upon its dissolution, the right of each individual to a share in the immovables is an immovable. 2. Immovables. Corporeal immovables. Tracts of land with their component parts are immovables. A. Buildings, other constructions permanently attached to the ground, standing timber, and unharvested crops or ungathered fruits of trees are component parts of a tract of land when they belong to the owner of the ground. B. Incorporeal immovables. Rights and actions that apply to immovable things are incorporeal immovables. Immovables of this kind are such as personal servitudes established on immovables, predial servitudes, mineral rights, and petitory or possessory actions. D. Common, public, and private things. 1. Common things. Common things may not be owned by anyone. They are such as the air and the high seas that may be freely used by everyone comfortably with the use for each nature has intended them. 2. Public things. Public things are owned by the state or its political subdivisions in their capacity as public persons. Public things that belong to the state, such as running waters, the waters and bottoms of natural navigable water bodies, the territorial sea, and the seashore. Public things that may belong to political subdivisions of the state, such as streets and public squares. B. Seashore is the space of land over which the water of the sea spread in the highest tide during the winter season. 3. Private things. A. Private things are owned by individuals, other private persons, and by the state or its political subdivisions in their capacity as private persons. 4. Public use. Public things and common things are subject to public use in accordance with applicable laws and regulations. Everyone has the right to fish in the rivers, ports, roadsteads, and harbors, and the right to land on the seashore to fish, to shelter himself, or moor ships to dry nets, and the like, provided that he does not cause injury to the property of adjoining owners. The seashore within the limits of a municipality is subject to the police power, and the public use is governed by municipal ordinances and regulations. B. Private things may be subject to public use in accordance with law or by dedication. 1. The banks of navigable rivers or streams are private things that are subject to public use. The bank of a navigable river or stream is the land line between the ordinary low and the ordinary high stage of water. Nevertheless, when there is a levee in proximity to the water, established according to the law, the levee shall form the bank. Boundaries. A. Definition. 1. Definition of a boundary. A boundary is the line of separation between contiguous lands. A boundary marker is a natural or artificial object that marks on the ground the line of separation of contiguous lands. A boundary need not be a fence or another enclosure, but may be evidenced by markings commonly used by surveyors. B. By boundary is understood, in general, every separation, natural or artificial, which marks the confines or line of division of two contiguous states. Trees or hedges may be planted. Ditches may be dug. Walls or enclosures may be erected to serve as boundaries. Aubrey v. Deggs, 1936. 1. The word enclosures means that the land actually physically and corporeally possessed by one as owner must be established with certainty by natural or artificial marks, sufficient to give definite notice to the public or character and extent of possession, to identify fully the property possessed and fix with certainty the boundaries of limits thereof. B. Fixing boundaries. 1. Fixing of a boundary. The fixing of a boundary may involve determination of the separation between contiguous lands. If it is uncertain or undisputed, it may also involve placement of markers on the ground. If markers were never placed or no longer to be seen, A. Boundary action is action brought by the owner or possessor of one or more contiguous tracts or lands to compel fixing of boundary between such tracts of land. 1. The owner, possessor, usufructuary, or lessee may be compelled the fixing of the boundary. 2. The right to compel the fixing of the boundary is imprescriptible. B. An action of boundary lies only where the adjoining estates have never been separated physically, where the two estates have been separated but physical boundaries are no longer visible, or where the bounds exist but have been placed incorrectly. Branch v. Hinson, 1966. 2. Location of boundary without fixing. When markers are placed on one of the contiguous owners alone, or by contiguous owners without written agreement, the boundary is not fixed. A demand for extrajudicial fixing of the boundary therefore be proper. If one of the contiguous owners has possessed, however, within the visible bounds without interruption for 30 years, the boundary shall be fixed according to lines established by prescription. 1. Early Louisiana law, Formal Civil Code, Article 838. Forbid a landowner to mark his boundary without notice to the neighbor to be present. It is also provided that the operation had no effect in the absence of notice of the contiguous neighbor, may have an action for damages that may have sustained. As a result of suppression of this article, a landowner may freely mark the boundary, but there should be no doubt that such a marking does not constitute extrajudicial fixing of the boundary. Moreover, there should be no doubt that the placement of the boundary markers by a landowner may constitute a disturbance of possession under Article 3455 of the Civil Code, or a wrongful act under Article 2315. 2. The law does not permit fixing of boundaries by an oral agreement except as between the parties themselves. Prather v. Valian. B. The more passive failure of a contiguous owner to object to the location of a fence or other marker, or the informal acquiescence of the contiguous owners to a jointly erected fence does not constitute a fixing of the boundary. An action of the correction of the boundary may be brought more than 10 years after the location of a boundary markers. There is no 10-year liberative prescription running because the acquiescence in the location of the boundaries does not constitute a contract. 3. The boundary may be fixed judicially or extrajudicially. A. Extrajudicially. The boundary is fixed extrajudicially when the parties, by written agreement, determine the line of separation between their lands, with or without reference to the markers on the ground. 1. Owners of contiguous lands may enter into a written agreement designating the boundary between their lands with reference to markers on the ground. They may utilize fences, natural monuments, or other boundary markers. A. An agreement between adjoining owners on the correct location of the boundary between the properties is the only kind of agreement that may dispense with the requirement that a judgment fixing the boundary between contiguous tracts must be preceded by establishment of the boundary line by a land surveyor or licensed civil engineer appointed by a court. Ballin v. Stafford. B. When a boundary sought to be reestablished was fixed by an agreement of the owners of adjoining estates, but was not predicated on a survey, the action to establish boundary is imprescriptible. Duplantis v. Seahan. 2. An error in the survey conducted before the boundary agreement is the error of the parties, and the error must be rectified before 10 years liberative prescription has run. A. Thus, owners of contiguous lands may determine the line of the separation on paper and then proceed to have it marked on the ground, or the boundary on the ground and then determine the line of separation and the reference of the markers. In either case, the agreement is an act of translative ownership and has the effect of a compromise. Ownership is conveyed respectively up to the line fixed by the agreement. The parties or the surveyor committed an error in the location of the line of separation, or the markers, or both. The error may be rectified by the courts unless the agreement is no longer available as a result of the 10-year liberative prescription. Judicially fixed by the court. The court shall fix a boundary according to the ownership of the parties. If neither party proves ownership, the boundary shall be fixed according to the limits established by possession. 1. When both parties rely on titles only, the boundary shall be fixed according to the titles. When the parties trace their titles to a common author, the preference shall be given to the more ancient title. A. Trial court properly gave preference to plaintiff's title in resolving boundary dispute where plaintiff's title was more ancient, deriving from 1952 sale, whereas defendant's title was derived from a 1962 sale from the common grantor, Williamson v. Kelly. 2. When a party proves acquisitive prescription, the boundary shall be fixed according to the limits established by prescription rather than titles. If a party and his ancestors in title possessed for 30 years without interruption, within visible bounds, more land than their title called for, the boundary shall be fixed along these bounds. A. 10-year acquisitive prescription. B. 30-year acquisitive prescription. And C. Where there is a visible boundary and there has been actual uninterrupted possession either in person or through ancestors in title for 30 years or more of the land, extending beyond the described in the title and embraced within the visible bounds, then the party who possesses acquires the right to the land beyond his title. Williams v. Peacock. 1. Visible bounds, sometimes referred to as enclosures, mean that the land is actually physically marked by natural or artificial means, sufficient to give definite notice of the extent of possession. 2. The burden of proof for visible bounds is the same for 30-year acquisitive prescription, Briggs v. Pallerin. And 3. Error in a survey conducted by the court becomes res judicata to the parties if cannot be attacked. C. Costs. When the boundaries is fixed extrajudicially, costs are divided equally between the adjoiners, owners of the absence of contrary agreement. When the boundary is fixed judicially by the court, costs are taxed in accordance with the rules of the Code of the Civil Procedure. Expenses of litigation not taxed as court costs are borne by the person who has incurred them. General rules that fixing the boundary is a benefit to both parties of the action, and hence costs should be shared. B. Where only one group of litigants provoke the necessity for a survey to determine the boundary between owners and show relationship of an old fence to a boundary expenses of the survey should be borne by those litigants. C. Costs incurred by the boundary suit are divided equally where there is no proof of demand on one side and refusal on the other side to settle dispute amicably. 1. Entire cost of surveyor's fees and expenses for field notes of chained men was chargeable to defendants as parties cast in the boundary case, where evidence showed that suit became necessary when defendants refused to join plaintiff in having survey made by the plaintiff had made boundary concessions. D. Removal of monuments. When the boundary has been made judicially and extrajudicially, one who removes the boundary markers without court authority is liable for damages. He may also be compelled to restore the markers to their previous location. 2. If the dependent pulls up the stakes fixed by the surveyor in an attempt to obliterate the marks of the same, he may be enjoined and the injunction cannot be released en bond. To permit defendant to destroy a survey made by order of the court, competent jurisdiction would make a farce of legal process and effectually obstruct the courts of justice.